Good morning, Alex and friends. I'm Grace. Today is Wednesday, August 19th, 2026, and you're listening to Alex's News. It is going to be a scorcher in Riverside today with a high of 102.1 degrees and a low of 69.9 degrees. Please make sure to stay cool and find some shade if you have to head outside this afternoon. Coming up on the program, we are looking into the legal conflict involving ABC and Disney as they challenge the FCC regarding First Amendment protections. We will also examine why labor organizations are taking the Department of Homeland Security to court over their recent changes to visa regulations. We will have those updates and a few other stories to round out the show. All that and more on Alex's News. Stay tuned. Good morning. There's a major legal showdown brewing between one of America's biggest media companies and a federal regulator. Ethan's been following it. Ethan, what happened yesterday?
Good morning, Grace. On Tuesday, August 18th, just yesterday, ABC and its parent company, the Walt Disney Co., filed a federal lawsuit against the Federal Communications Commission. They're alleging the agency violated their First Amendment rights. The heart of the claim is that the Trump administration has waged what they call a retaliatory campaign, and they say it's because the administration disapproves of the network's broadcasts.
That's a bold accusation. How serious do they say this threat is?
They're not mincing words at all. ABC and Disney describe the FCC's actions as, quote, an existential threat, end quote. That's about as strong as corporate language gets. And it signals they believe their entire broadcast business could be at risk here. So this isn't a minor regulatory squabble in their view. They're framing it as a fight over the future of the company.
So what's the specific action that sparked all this?
The central issue is a decision the FCC made back in April of this year. The agency moved to force 8 ABC-owned local TV stations to undergo an early review of their broadcast licenses. And these aren't small stations. They include stations in 6 of the largest U.S. markets. Normally, these licenses run for 8-year terms, so pulling them in for review years early is highly unusual.
Why would the FCC want to review those licenses so early?
Well, that's exactly what ABC is questioning. The plaintiffs allege these actions were taken to appease President Trump. He's frequently condemned ABC's news coverage, the show The View, and Jimmy Kimmel. ABC is leaning on a Supreme Court decision, NRA versus Volo, to make its case. They argue the government is using state power to punish expression it simply doesn't like.
You mentioned Jimmy Kimmel. What's his role in this story?
Reports indicate the early license review actually followed a joke by Jimmy Kimmel that infuriated the president. And the lawsuit gets even more specific about the pressure. It quotes FCC Chairman Brendan Carr, who's a Trump ally appointed in November of last year. According to the suit, Carr told the network they could, quote, do this the easy way or the hard way, end quote. He suggested that failing to take action against Kimmel would mean additional work for the FCC.
That sounds like a threat. How has Chairman Carr responded to all this?
Carr has defended the agency's actions pretty firmly. He asserts the FCC is simply ensuring that broadcasters, quote, operate in the public interest, end quote. But there's another angle the agency has emphasized. The FCC and a commission spokesperson specifically cited ABC's diversity, equity, and inclusion practices, often shortened to DEI. They claim the agency is investigating whether Disney engaged in what they call illegal DEI discrimination and violated a presidential executive order.
So the license review isn't the only investigation. What else is the FCC looking into?
That's right, there are actually 2 other investigations running alongside it. The first involves fairness and equal time. The FCC is examining whether The View failed to provide equal time to candidates for office. That came after an appearance by James Tallarico. ABC's defense is that the show is a, quote, bona fide news program, end quote, which would make it exempt from those equal time rules.
And the second investigation?
The second one goes right to the heart of Disney itself. It's what they call an owner fitness investigation. The FCC is looking into Disney's DEI policies to determine whether the company is a, quote, fit owner, end quote, of its broadcast licenses. So essentially, the agency is questioning whether Disney should be allowed to hold those licenses at all, That's why the company sees this as such a fundamental threat.
Let's step back a bit. Is this a change in how the FCC normally operates?
It really does reflect a shift in the Commission's role. President Trump has stated he views the FCC as an extension of the executive branch. That's a notable departure, because the agency has traditionally been an independent regulator, and not everyone inside the Commission agrees with the direction. Commissioner Ana Gomez, who's the sole Democrat on the Commission, commended ABC and Disney for fighting what she termed a campaign of censorship.
Has Disney faced pressure from the Trump administration before this?
Yes, and that context is important. This legal battle follows a period of real tension. Disney and other media giants, including Meta, X, and Paramount, all settled private defamation lawsuits filed by Trump. In Disney's case, back in December of 2024, ABC paid $16 million to settle a suit regarding remarks by George Stephanopoulos. So there's a pattern of companies choosing to settle rather than fight.
So why is Disney fighting this time instead of settling?
That's the key shift here, Grace. Despite all these pressures, Disney appears to be drawing a line. Disney CEO Josh D'Amaro told CNBC that the company will stand up for journalistic integrity. He said the company, quote, not going to be told how to run, end quote, its news business. So after a stretch of settlements, this feels like a very deliberate decision to push back in court.
What are the biggest questions still hanging over this case?
The central legal question will be whether ABC can prove the FCC's actions were genuinely retaliatory rather than routine oversight. That NRA versus Volo precedent will be tested here because it deals with the government using its power to punish disfavored speech. We'll also be watching what happens to those 8 stations while the case plays out. And the DEI investigations add a whole separate layer that courts will have to untangle.
And what should our viewers watch for in the days ahead?
I'd keep an eye on how the FCC formally responds to the lawsuit, since they haven't filed their court answer yet. It's also worth watching whether other networks weigh in, given that Meta, X, and Paramount have all faced similar pressure. And Jimmy Kimmel and The View remain at the center of this, so anything happening with those programs could matter. This is a story that could reshape the relationship between broadcasters and the government.
Fascinating and consequential stuff. Ethan, thanks so much for breaking it all down for us.
My pleasure, Grace. I'll keep following it and bring you updates as they come.
Welcome back. Now to a legal fight brewing over international students and a new federal rule. Chloe, what's going on here?
Good morning, Grace. So on Tuesday, August 18th, just yesterday, a broad coalition of labor unions and higher education organizations filed a lawsuit in the U.S. District Court for the District of Massachusetts. They're trying to block a new Department of Homeland Security rule. The coalition wants the court to vacate the rule entirely, and they're asking for a preliminary injunction to stop it before it takes effect on September 15th, less than a month from now.
So what exactly does this DHS rule change?
This is the big one, Grace. The rule was finalized back in July of this year, and it eliminates something called the Duration of Status Framework. For years, that framework let foreign students and exchange visitors stay in the U.S. for as long as their academic programs lasted. According to reporting from Higher Ed Dive and Forbes, the new rule scraps that flexibility and replaces it with rigid, fixed admission periods. In other words, a hard clock instead of an open-ended stay.
A hard clock. So how long can students actually stay now?
For F student visas and J exchange visitor visas, admission is capped at a maximum of 4 years. If students need more time to finish their degrees, they have to apply for discretionary extensions. And there's a separate track for foreign journalists on I visas. They're generally limited to 240 days. But journalists holding passports from the People's Republic of China, excluding Hong Kong and Macau, are limited to just 90 days. Extensions are allowed, but they can't exceed the length of the journalist's assignment.
That's a striking difference for Chinese journalists. Are there other restrictions buried in this rule?
There are, and some of them are pretty consequential. The rule puts strict limits on students who want to transfer schools or change their academic programs. It specifically bars students from starting a new course of study at the same or a lower educational level than a program they've already completed. So if you finished one master's degree, you couldn't easily start another. And for F1 students, the grace period after finishing a program gets cut from 60 days down to 30 days. That's half the time to pack up and figure out your next move.
Let's turn to the people fighting this. Who's actually behind the lawsuit?
It's a wide coalition, Grace, and the names matter here. It includes NAFSA, Association of International Educators, the Presidents, Alliance on Higher Education and Immigration, and the Association of Independent Colleges and Universities in Massachusetts. On the labor side, you've got the American Federation of Teachers, the Graduate Labor Organization, which is AFT Local 6516, the United Auto Workers, including UAW Local 2322, and the News Guild CWA. Their central argument is that the rule is, quote, arbitrary and capricious, end quote, under the Administrative Procedure Act.
Arbitrary and capricious. What's the heart of their case?
They make a few distinct arguments, according to Higher Ed Dive and Forbes. First, academic impracticality. They say a 4-year cap just isn't enough for many programs, especially doctoral degrees, which routinely run longer. That forces students to lean on what they call an overwhelmed federal bureaucracy for extensions, with no guarantee of approval. So a student could be halfway through a PhD and suddenly face uncertainty about whether they can even finish.
And beyond the practical problems, are they claiming the rule breaks the law?
Yes, that's their second major line. By barring students from pursuing degrees at the same or lower levels, the coalition says the rule actually violates existing immigration statutes. Those statutes expressly make such students eligible for F visas. So the argument is DHS is contradicting the law Congress already wrote. And then there's a third piece: procedural failures. They claim DHS didn't adequately quantify the costs and benefits of the rule, and that the agency ignored roughly 22,000 public comments that voiced what they describe as near universal opposition.
22,000 comments is a lot to set aside. Let's talk money. What's the economic argument?
This is where the lawsuit really leans in, Grace. They warn of, quote, catastrophic, end quote, consequences for both the economy and university systems. Citing National Science Foundation data, Forbes notes that international students are absolutely central to STEM fields. They make up 80% of full-time graduate students in computer and information sciences, 75% in electrical and computer engineering, and 62% in mathematics and statistics. So we're talking about the backbone of some of the country's most competitive research areas.
Those numbers are huge. What about the broader dollar figures?
The complaint cites what's called a Clemens study, and the estimates are striking. It suggests eliminating duration of status could cost the U.S. between $72 billion and $145 billion annually within 10 years. And lost productivity growth could reach up to $439 billion per year by the 10th year. There's also a jobs angle. The complaint says every 3 international students create 1 additional U.S. job, and roughly 1/4 of U.S. billion-dollar companies were co-founded by international students.
So this reaches well beyond campuses. Any local impact worth noting?
Definitely, and Massachusetts is a good example, which makes sense given where the suit was filed. The Association of Independent Colleges and Universities in Massachusetts points out that the state has over 80,000 international students. Together, they generate more than $4 billion in annual economic impact. So when you hear about a rule like this, it's not abstract. It touches local businesses, housing, research labs, and jobs in a very concrete way.
Now let's hear the other side. How is DHS defending the rule?
The Trump administration frames this as a necessary national security measure, one meant to cut down on fraud and abuse. According to Higher Ed Dive, DHS argues that the open-ended nature of F&J visas invites abuse. They cite data showing that 2,100 international students who entered between 2000 and 2010 still held active F visas as of April 2025. A DHS spokesperson even questioned the lack of, quote, outrage, end quote, when foreign nationals, quote, make a mockery, end quote, of immigration laws.
How do the plaintiffs answer that fraud claim?
They push back hard, Grace. They call these justifications, quote, scattered anecdotes, end quote. And they do the math on that headline number. Those 2,100 individuals, DHS, points to represent only 0.067% of the estimated 3.1 million F1 students who entered during that decade. So a tiny fraction. They also argue the 4-year extension cycle is, quote, absurd, end quote, as a security tool, because a genuine bad actor could simply finish a program quickly and avoid the scrutiny of an extension application altogether.
So both sides are really talking past each other on what this rule accomplishes. What happens next?
That's the key question. The clock is ticking toward that September 15th effective date, so the plaintiffs are asking the court to move quickly on that preliminary injunction. If the judge grants it, the rule would be paused while the larger legal fight plays out. If not, universities and students could be scrambling to adjust with very little runway. Either way, this is a case a lot of schools, employers, and international families will be watching closely in the weeks ahead.
Really important story with a lot at stake. Chloe, thanks so much for breaking it down for us.
Happy to, Grace. Thanks for having me.
Here are some other headlines. Tensions are reaching a boiling point in the Middle East as President Donald Trump really puts the squeeze on Oman. On Monday, August 17, 2026, the president threatened to bomb the nation, claiming he is dissatisfied with their progress toward a deal with Iran to manage ship traffic through the Strait of Hormuz. This is not the first time he has cast a shadow over the region, as he previously warned in May that Oman would either behave or face a total blast. The U.S. administration is currently sinking any hope for a deal, objecting to the joint Iranian and Omani management of the Strait's exit route and Oman's plan to collect voluntary fees for security and environmental protection. President Trump is taking things a step further, mapping out a new reality. On Tuesday, August 18th, he posted a map on social media claiming the Strait of Hormuz as U.S. territory, having already told reporters in the Oval Office that he likes the idea of declaring it a territory. Iranian Deputy Foreign Minister Kazem Gharibabadi has dismissed these territorial claims as a total delusion, essentially telling the president to get his head out of the clouds. Meanwhile, the region is sailing into dangerous waters. The British military's Maritime Monitoring Agency reports a projectile hit a ship exiting the strait, while another cargo vessel off the coast of Yemen has become a constructive total loss after being hit by multiple projectiles. The UAE Defense Ministry is also on high alert, reporting that 2 ballistic missiles were launched from Iran toward the UAE. Iran has made it clear that the strait will remain closed until the U.S. meets their demands, which include lifting the blockade, releasing frozen assets, ending oil sanctions, and stopping all military operations. Turning our attention back home, the political heat is rising as we look at the fallout from Tuesday's primary elections in Florida, Alaska, and Wyoming. It is a high-stakes game as candidates fight for their spot on the ballot. Finally, in a heartwarming turn of events, we are seeing a global helping hand to fight the flames. Australia and New Zealand are sending their largest contingent of firefighters ever to assist U.S. crews in battling the devastating wildfires. It is truly a breath of fresh air to see these nations stepping up to help us put out the fire. That's all we have for now. Today's episode was made by Alexander King with Claude Opus 4.8, Gemini Pro 3.1, Gemini Flash 3, and Google Cloud Text-to-Speech. I hope you have a great day. I'll see you tomorrow, Alex.